A single judge can erase more than evidence. Sometimes, they erase hope itself. In 1977, a conviction on Docket 76 CR 1045 stood, despite evidence box 12 going missing, and files mysteriously altered years after the trial. If justice can be rewritten in the shadows, what chance does anyone have to escape a system built to deny them? The truth behind this courtroom disaster begins now. A forensic specialist sits at a terminal, scrolling through the raw hex output of a court document. The file's metadata tells a story no one expected. The docket for case 76 CR 1045 was officially closed in 1977, yet the digital record shows a last modified timestamp from 1980, a full 3 years after the case should have been locked away. On screen, the specialist points out the mismatch. The file's cryptographic hash, a digital fingerprint, no longer matches the original logged at closure. This is not a simple clerical error. In the world of digital forensics, a hash mismatch means the file was altered after the fact. The specialist explains that computer systems stamp every edit with a precise date and time. When those timestamps jump forward, or worse, jump backward, without a record of authorized access, it signals tampering. The document's history now contains a gap, an unexplained window where the record could have been rewritten. For anyone appealing a conviction, this kind of anomaly is catastrophic. Courts rely on the integrity of the digital record to decide whether new evidence or procedural errors justify reopening a case. If the file itself cannot be trusted, every subsequent motion, every plea for relief, is built on sand. The altered metadata becomes a silent witness, undermining confidence in the entire appeals process and casting doubt on whether justice was ever possible. Inside the evidence room, the inventory log for Box 12 tells a story in silence. The entry from October 13, 2019 lists the box as present, sealed, and containing 3 items flagged for appellate review. Hours later, the next inventory check records Box 12 as empty, with no explanation, no chain of custody signature, and no log of who entered or left. Surveillance footage from that day covers every other hour, except for a 5-hour gap where the camera's feed drops to black. During that window, the access log shows no sign-in, no badge swipe, nothing. By the time the clerk on duty returns, Box 12 sits on the shelf, lid open, the contents gone. The clerk's statement, notarized and filed, describes her confusion as she flips through the logbook. No initials, no timestamp, just a void. For anyone seeking a new trial, the missing contents of Box 12 mean more than lost evidence. Without those materials, the appellate process grinds to a halt. The timeline, overlaid with each missing hour, traces how a single gap can erase years of work. For families waiting on answers, the empty box becomes a symbol, proof that the very system meant to protect the truth can let it vanish, leaving only questions and closed doors. 3 decades of parole hearings, and the answer was always the same. Each year, the Illinois Prisoner Review Board stamped denied on the application, citing the gravity of the crime. But behind the official language, another pattern surfaced. A sworn affidavit from Jorge Montes, former chair of the board, described a chilling reality. Some members, he wrote, would never vote in favor of parole for someone who had killed a member of law enforcement. In one photograph entered into the record, uniformed officers stand directly behind board members as they deliberate, a silent wall of authority just feet away from the decision makers. For the families waiting outside, hope faded with every new denial. A sister, voice trembling, recalls hearing the verdict echo down the hallway, her hands clutching a photo of her brother taken before the trial. The board minutes, stacked year after year, tell a story of categorical refusal, not individual review. With each denial, the path to freedom narrowed, until the only option left was to challenge the very system that kept the doors closed. On March 24, 2020, the appellate court issued its final word. It contained a single sentence. The judgment of the circuit court is affirmed. The opinion dismissed claims of judicial corruption, stating the record did not show a direct connection between Judge Frank Wilson's bribery and the case at hand. The panel noted Operation Greylord did not begin until years after this conviction, and they found no evidence that the outcome was tainted. A receipt from the post office confirms the decision reached the last known address. No signature was ever returned. Attempts to contact Judge Wilson for comment went unanswered. He died in 2007, long before the scope of his misconduct came to light. Certified letters sent to the court's administrative office remain unclaimed, each envelope stamped with the words, "Return to sender." The file closes. No further review is granted. The official record stands, untouched by the doubts and pleas that trailed it for decades. The questions left behind go in empty mailboxes and silent phone lines, unanswered and unacknowledged. Right now, more than 1,200 judges face active misconduct investigations nationwide. When accountability fails, justice is not just delayed, it is denied. The system's silence is not neutrality, it is complicity. What would you demand?